C'est toi qui commence.
Oui. Peux-tu me mettre sur le vidéo, s'il te plaît?
Oui.
Hello, and welcome to our webcast for September 13, 2019. My name is Christian Lebré, and this is Amy Asbrook, the director of Toujours Vivant, Not Dead Yet.
Hello.
I'll try to arrange the background one way or another. Sorry, it's a live video. Okay. Also, not joining us, Taylor Hyatt, who are right now doing an interview over another
media.
Yep. Okay, thank you. Toujours Vivant, Not Dead Yet is a non-religion organization by and for people with disabilities and our allies. Our goal is to inform, unify, and give voice to the disability rights opposition to assisted suicide, euthanasia, and other ending of life practices that discriminate against people with disabilities. Today's topics, we have two, but very big one, a very important one. Québec court decide Truchon Gladu case. Very important. And the second one, Dutch doctor acquitted in euthanasia of women with dementia. And this is hard thing.
Yeah, okay. So these are both very difficult topics, and we've learned about the Quebec decision on Wednesday and didn't have much time to prepare. So unfortunately, this is a short webcast, but that's okay. Quebec court decides Truchon Gladu case. A Quebec Superior Court has ruled unconstitutional the portion of the federal medical assistance in dying law that limits eligibility to people whose natural death has become reasonably foreseeable, and the requirement in Quebec's euthanasia law that the person must be at the end of life. So basically, this opens up the law to people with all kinds of disabilities regardless.
Basically, it was the last boundary not to step over, and it is done.
Right,
step over.
For people with disabilities.
Yeah.
In a 186-page decision, Judge Christine Baudouin confused the plaintiff's physical limitations and inability to live independently, ignoring the public policy that limits their choice by preferring institutional over consumer-driven in-home personal assistance services. So the policy is the problem. The policy favors institutional care over home-based services.
Yeah.
Nor did the court mention Canada's obligation under Article 19 of the Convention on the Rights of Persons with Disabilities to provide services to enable disabled people to live independently in the community.
So it's really bad because we have signed this agreement.
Yeah.
We take part of this agreement and we deny our signing.
Right, and that's something that came up in the Sean Taggart case. He was denied enough home-based services so that he could live independently, and his only choice was to go into an institution. He opted instead for euthanasia.
Yeah, it's instead, okay? You have to understand it. The choice is not to live or not to live. The choice is we have to live within a kind of prison or to be dead. And a lot of people choose to be dead instead to be in kind of prison.
Right. The Truchon Gladu decision brings to mind the 2012 British Columbia trial court ruling in the Carter case, which was a foundation of the Supreme Court's decision to overturn the ban on assisted suicide and euthanasia. So it uses the same kind of pitying language. It uses the same kind of doctor knows best language. It's throughout the decision.
Yeah. Doctors are good in medical decision. In average, they are very good. But socioeconomic, oh no.
Yeah.
Inquiry, no.
Right. We haven't finished reading the decision yet. It's a long one, so a more detailed analysis will have to wait for another webcast. We offer some initial thoughts. The judge placed great confidence in doctors' ability not only to assess medical eligibility, but also a person's decision-making capacity and the impact of social and economic pressures on made requests.
So they become instantly the final decision for everything. They are the expert in everything, socioeconomical thing, and so on and so on.
Right, and the court ignored studies that have been done that say that doctors don't actually use the tools that they're supposed to assess capacity. So the court just decided that those studies weren't important.
On the side and not looking up.
Right. This adherence to the medical model of disability, which cites the problem of disability with the individual while ignoring society's responsibility to accommodate the full range of humanity, is a setback for the disability rights movement and really for all people with disabilities. However, the court failed to question why pain management techniques were ineffective for the plaintiffs, nor the fact that palliative care is often unavailable or inadequate. So the court just accepted that these people were in pain, but doctors know what they're doing, even though the doctors weren't managing the pain effectively.
Yeah.
So
and even in medical decision, pain management is a specialty. They are not all as good as they could, okay? They are not specialists in pain management. They are specialists in general medicine, most of them.
Right. The court applies a presumption of competence to the plaintiff's requests for euthanasia, saying, quote, like any other able and knowledgeable person, persons with disabilities may have a rational and legitimate desire to end their lives, given their condition. But in fact, any other non-disabled person who expresses a wish to die is not considered a rational and legitimate desire to end their lives, but rather evidence of suicidality, if not incompetence. We believe the court is implying a discriminatory double standard that limits access to suicide prevention services to people with disabilities.
And the key word is rational. Right now, they think if somebody think about suicide, so it's first time in the history of Canada that the suicide become rational.
Right.
Okay.
Exactly.
It's very, very, very dangerous.
Right. Yes. I mean, the court, by saying that suicide is a rational option, no one said that before, and that's not okay.
And what are doing all the groups are opposing to suicide? I don't know what they're doing. They just don't see what the game playing right now. They are out of game.
Right. The court distinguishes the plaintiffs by their physical limitations, poorly managed pain, and their dependence. Though all of these factors are directly related to disability, they are caused by inadequate medical care, discriminatory social policies, and attitudes about disability. So they're related to the disability, but they're not caused by the disability. And I was listening earlier to the interview that Taylor was on, and the people who called in and all the quote unquote experts just had no concept of this stuff. And it's very frustrating. Okay, so that's the end of our first topic. Our second topic, Dutch doctor acquitted in euthanasia of woman with dementia. A Dutch doctor was cleared of wrongdoing in the euthanasia death of a 74-year-old woman with dementia. As we reported last year, and there's a link in the text to the report that we discussed, officials in the Netherlands brought charges against a doctor who performed euthanasia on a woman who had signed an advance directive requesting euthanasia several years previously, but was giving mixed signals about her desire to die when she was given the lethal injection. In addition, the doctor put a sedative in the woman's coffee and had family members hold her down while she struggled against the injection. So that's pretty mixed signals.
Yeah, it's more than mixed signal. It's an assassination. It's nothing else.
Right. But the doctor was cleared of any wrongdoing.
And you know why? Because in all the law who are copied from one to another, Netherlands, Belgium, and Canada, the thing is that if the doctor think that is what the patient wants, he's clear of everything. So he just have to say, I was thinking that she want to die.
Right.
And that's it. He's clear of everything.
Right. Though it's interesting because in a way there's evidence that the doctor didn't believe that because the doctor put sedative in the coffee. So, yeah. Anyway.
But he just have to say that, even if he put a sedative in his coffee.
Right. Okay. Judges in The Hague said the doctor met all criteria, though prosecutors alleged that the doctor made insufficient efforts to verify that the woman wanted to die.
He made his effort to kill her.
Right. Yeah. He certainly put that effort out. The advance directive stated that the woman wanted to die, quote, whenever I think the time is right, unquote. In the weeks leading up to the euthanasia, witnesses testified the woman stated, not just now, it's not so bad yet. So that's a pretty mixed signal.
Yes.
Prosecutors are deciding whether to appeal the ruling. This ruling establishes the legal principle that an advance directive will be taken as a binding statement of a person's wishes.
Yes, a binding statement.
Means you're bound by the statement. Means you're tied to it. You can't.
That sometimes you have done 5, 10, 15 years before.
Right.
And you don't have really the right to change.
It's a binding statement of the person's wishes should the person later be deemed incompetent to make decisions for themselves. And sometimes incompetence isn't a question of incapacity, it's when the person can't communicate effectively, and there's no provision made for that. Activists believe such policies pose a danger to people who, upon adapting to a disability, which most people do, are satisfied to live with a disability. Thus, people with dementia are not allowed to change their minds should they decide that life with a disability is not, in fact, worse than death. But too bad you don't have a choice.
Yeah.
If you're deemed incompetent.
Yeah, you had signed the paper a few years before and you doesn't have the right to change.
Yeah. If you want more information about the subjects that we discuss here, you can visit our Facebook page at facebook.com/toujours vivant, not dead yet. You can visit our website at tvndy.ca. You can email us at info@tv-ndy.ca, or you can follow us on Twitter @TVNDY. Thanks to Christian for helping us out.
Thank you, Amy.
And you can click on